A very warm good afternoon to all of you. This is Pratyush Kumar, Research Associate, National Law University, Delhi. I shall be speaking on trade-related investment measures this afternoon. The period of decolonization in Asia and Africa began in the 1940s. It was during this phase when the world economy, led by colonial, formerly colonial, and presently the developed world, was trying to recover from the effects and after effects of Second World War. The initial plan of Havana Charter in 1948 was to form International Trade Organization, which had investment also as a component in its formulation. This charter never saw the light of day, and only commercial policy was adopted in GATT 1947, General Agreement on Tariffs and Trade 1947. It was only during the Uruguay round of negotiations that investment received attention and then became part of the jurisprudence evolved by WTO. Though the principle of protection of investment is quite old, going back to the days of laissez-faire of 19th century US and UK, but in its present form, it has evolved after the Second World War. In 1959, through the Resolution on International Investment for Economic Development, the GATT contracting parties were encouraged to conclude bilateral agreements to promote and protect foreign investment. Later on, through GATT, National Treatment Principle entered the investment law regime. The developed countries got together under the aegis of OECD, Organization for Economic Cooperation and Development, to develop a comprehensive agreement on investment in the 1990s, which is known as Multilateral Agreement on Investment, MAI. This agreement never took off as developing countries were not made a party to the negotiations, and they became deeply suspicious of the manner and motives of such an agreement. Furthermore, OECD is a closed organization of developed nations, which made it more difficult for them to sell the idea of MAI. It was disbanded in 1998. Then again, developed countries wanted to have a multilateral initiative under the aegis of World Trade Organization through Doha round of negotiations. Here again, there was a clash of priorities. The developing countries had other pressing issues to be concerned with, like agriculture, textiles, special and differential treatment across the board for developing and least developed countries, access to medicines and life-saving drugs, and a multilateral agreement on investment went on a back burner under the aegis of WTO. In fact, the whole Doha development agenda got derailed. This did not restrict states from developing an FDI policy at national, bilateral, and regional level and pass off as an exception under Article 24 of GATT. Trade liberalizing measures, GATT, GATTs, and TRIPS have a direct impact on even investment, like for exporting companies to set up customer services center covered under GATTs in importing countries to facilitate trade. This is a kind of investment in the services sector. In this backdrop, through the Uruguay round, when under the auspices of WTO, TRIMS was negotiated, it had a very limited scope of application. Through the agreement and its illustrative list, it only strengthened Article 3 requirement of national treatment and Article 11 requirement of quantitative restrictions under GATT. It therefore in no way is as comprehensive and liberalizing as GATT, GATTs, or TRIPS for that matter. TRIMS has a very narrow focus. It essentially concerns itself with national treatment and quantitative restrictions, and does not provide a comprehensive investment regime for WTO member countries. The FIRA panel, 1984. It all began with the 1982 case concerning Canada Foreign Investment Review Act 1973, which was challenged by the US as trade restrictive under GATT. The Canadian legislation was enacted because of an element of national concern to counter and reverse the trend of Canadian industry, trade and commerce being dominated by non-Canadians. The relevant provisions of FIRA 1973 are sections 2.2 to 2.7. They are as follows. 2.2 Foreign Investment Review Act. In December 1973, the Parliament of Canada enacted the Foreign Investment Review Act. According to Section 2.1 of this Act, the Parliament adopted the law in recognition that the extent to which control of Canadian industry, trade and commerce has been acquired by persons other than Canadians and the effect thereof on the ability of Canadians to maintain effective control over their economic environment is a matter of national concern, and that it was therefore expedient to ensure that acquisitions of control of a Canadian business or establishments of a new business by persons other than Canadians be reviewed and assessed and only be allowed to proceed if the government had determined that they were or were likely to be of significant benefit to Canada. Section 2.2 lists 5 factors to be taken into account in assessing whether a proposed investment is or is likely to be of significant benefit to Canada. These are the effect of the acquisition or establishment on the level and nature of economic activity in Canada, including without limiting the generality of the foregoing, the effect on employment, on resource processing, on the utilization of parts, components and services produced in Canada, and on exports from Canada. The degree and significance of participation by Canadians in the business enterprise or new business and in any industry or industries in Canada of which the business enterprise or new business forms or would form a part. C. The effect of the acquisition or establishment on productivity, industrial efficiency, technological development, product innovation, and product variety in Canada. D. The effect of the acquisition or establishment on competition within any industry or industries in Canada. And E. The compatibility of the acquisition or establishment with national industrial and economic policies, taking into consideration industrial and economic policy objectives enunciated by the government or legislature of any province likely to be significantly affected by the acquisition or establishment. Written undertakings given by investors. The Act provides that investors may submit written undertakings on the conduct of the business they are proposing to acquire or establish, conditional on approval by the Canadian government of the proposed acquisition or establishment. The submission of undertakings is not required under the Act, but as the administration of the Act evolved, they are now routinely submitted in support of nearly all larger investment proposals. Many undertakings are the result of negotiations between the investor and the Canadian government. Undertakings given by investors may deal with any aspect of the conduct of a business, including employment, investment, research and development, participation of Canadian shareholders and managers, productivity improvements, as well as practices with respect to purchasing, manufacturing and exports. There are no preset formulas or prescriptions for the undertakings. Purchase undertakings. Undertakings with respect to the purchase of goods have been given in a variety of forms. Some involve best efforts to seek Canadian sources of supply. Some specify a percentage or amount of purchases of Canadian products. Some envisage replacement of imports with Canadian-made goods in a specific dollar amount. Some refer to the purchase of Canadian products, others only to the purchase from Canadian suppliers, whether of domestic or imported goods. Some involve a commitment to set up a purchasing division in the Canadian subsidiary, and some involve a commitment to consult with federal or provincial industry specialists in drawing up tender lists. Undertakings on purchases are often but not always conditional on goods being available, reasonably available, or competitively available in Canada with respect to price, quality, and delivery, or other factors specified by the investor. Manufacturing undertakings. Some firms have given undertakings to manufacture in Canada products or components of a product used or sold by the firm. Export undertakings. The undertakings involving the export of goods have been given in a variety of forms. Some involving development of natural resources are predicated on the development of offshore markets. Some involve a specific export target expressed as a percentage of output or sales, often to be achieved within a specified time frame. Some involve assigning to the Canadian business exclusive rights to export either all its products to certain countries or specified products on a world basis. Some involve a commitment by the investor to assist the Canadian subsidiary in selling its products in foreign markets, and some involve commitments that the Canadian business will not be restricted from seeking out and taking advantage of any export opportunities. Such legislation placing restrictions on investment in this manner would effectively hit national treatment requirement, Articles 3.4 and 3.5 of GATT, General Agreement on Tariffs and Trade, Quantitative Restrictions Requirement, Article 11 GATT, and Non-Discrimination by State Trading Enterprises, Article 17 1C of GATT. Another claim by US was how such an act would also lead to nullification and impairment under Article 23 of GATT. In the US's claim, it was not the act per se which was contested, because it was out of the purview of GATT, but only the trade-related issues. Contrary to the US's claim, we see how the decision in this case actually ended up intruding into the area of international investment. Canada claimed its actions to be an exception under Article 20D GATT as part of its laws and regulations not being inconsistent with the provisions of GATT 1947. The panel decided in favor of US, and as a result of it, Article 3.4 of GATT 1994 was specifically incorporated as part of the larger WTO trade regime. Trade-related investment measures, or TRIMs, is a result of the ratio of this case. TRIMs only codified the law evolved under Article 3.4 of GATT. These are some of the churnings which profoundly influenced the future WTO's character through the Marrakesh Agreement in 1994. Two main ideas emerged from the FIRA panel decision. National treatment principle got upheld in the investment context through its inclusion of local content requirement. Export performance requirements were not covered by GATT. Thus, there was a restrictive reading of trade-related requirements which expanded phenomenally in the Uruguay round of negotiations, leading to the formation of World Trade Organization. Now, the Uruguay round of negotiations limited the scope of TRIMs to Articles 3 and 11 of GATT 1994. In fact, more specifically to Clause 4 of Article 3 and Clause 1 of Article 11 mentioned in the annexure to TRIMs, which has given the same as an illustrative list, not necessarily exhaustive. The panel's holding of local content requirement to be inconsistent with the national treatment requirement became an established principle through the FIRA panel case, which precedes the formation of WTO despite opposition from developing countries. TRIMS covers three broad areas which are trade restrictive: local content requirements, trade balancing requirements, export restrictions. After the formation of WTO, one of the first cases to deal with the issue of local content requirement was Indonesia Autos case. In Indonesia, by its 1993 program and then again by the 1996 National Car Program, provided car companies, almost always benefiting Indonesian car companies, using local content: A. Import duty restrictions. B. Exemptions on imported automotive parts having local content, luxury tax exemption, import duty exemption. Now, even when such national car companies imported parts and components, they received customs duty benefits. The only requirement which they needed to fulfill was to have a certain percentage value of domestic products, local contents in their cars. Two questions had to be looked into by the WTO panel. They were: A. Whether the Indonesian measures at issue are investment measures. B. Whether these measures are trade related. The panel found the measures to be investment measures because they aimed at encouraging the development of local manufacturing of finished motor vehicles as well as their parts and components. The panel held the measures to have a significant impact on investment inherently. The panel decided the second question also in the affirmative by mentioning how, if such measures are local content requirements, they would invariably tantamount to trade related because they adversely affected trade by favoring domestic products over imported products. Some issues were not included in TRIMS as a result of Uruguay round of negotiations, which are, for example, export performance, technology transfer requirements. The objectives of TRIMS can be culled from its preamble, which includes the following points: the expansion and progressive liberalization of world trade to facilitate investment across international frontiers. TRIMS Article 1 applies to investment measures related to trade in goods only, therefore does not apply to services. Some salient features of trade-related investment measures are: TRIMS is not defined in the agreement. It provides a set of measures in its annexure which would be inconsistent with GATT, thus defining itself negatively. Therefore, the measures should not be inconsistent with Article 3.4 or Article 11.1 of GATT 1994. The agreement is not concerned with regulation of foreign investment. The focus of TRIMS is on non-discrimination between imported and exported products and or creation of import or export restrictions. It restricts the imposition of local content requirement even if national treatment principle is followed, because it would invariably restrict investor production for trade and tantamount to discriminatory treatment of imported goods in favor of domestic goods. Disputes under TRIMS are covered by Dispute Settlement Understanding (DSU), vide Article 8 TRIMS. Article 8 Consultation and Dispute Settlement. The provisions of Articles 22 and 23 of GATT 1994 as elaborated and applied by the Dispute Settlement Understanding shall apply to consultations and the settlement of disputes under this agreement. Article 6, which talks of transparency. Members reaffirm with respect to TRIMS their commitment to obligations on transparency and notification in Article 10 of GATT 1994 in the undertaking on notification contained in the understanding regarding notification, consultation, dispute settlement and surveillance adopted on 28 November 1979 and in the ministerial decision on notification procedures adopted on 15 April 1994. Now, which are the issues of contention? On the issues of investment, both the developed as well as the developing countries are deeply divided. The contradictions concern some of the following issues. A. Freedom of investment and its after effects of increase in foreign exchange and resultant inflation and other problems. B. Denationalization of national assets. There is constant fear among developing nations that their sovereignty over their own natural resources would be usurped by multinational corporations, and once their purpose is served, these host countries would be left high and dry. C. Less foreign direct investment in new companies and more as mergers and acquisitions of companies which already exist. This is seen as predatory capitalism of MNCs, which would then be the sole players, thus discouraging competition, which was the initial trigger factor for allowing greater investments. D. Lack of transparency. E. Local content requirement. F. Currency controls. G. Issues not just of FDI but also portfolio investment and extensions of credit. H. Expropriation. I. Problems of natural resources and infrastructure. J. Environment. K. Balance of payment problems and financial crises. Capital account convertibility. Flight of capital leading to Southeast Asian economic crisis beginning with Thailand in 1997. Countries like Indonesia have taken years to recover. The case in point is highlighted by Professor Jagdish Bhagwati in his work in Defense of Globalization, which highlights how countries like China and India were not affected by the economic crisis of 1997 because they charted their own individual economic policy as against being governed by the duo of World Bank and IMF. The 1999 economic crisis in Argentina is also a lesson for all developing countries. M. Monopoly of MNCs leading to inflation and resource inefficiencies adversely affecting social indices and public welfare. Now, there are certain themes which could be covered under trade-related investment measures. They are expropriation and nationalization. An investor wants some predictability in the investment policy of a country, which ensures their investment is not just secured, but also gives them their projected returns. Such expropriation would include any kind of creeping or indirect expropriation as well. 2. Repatriation of capital. The profit generated through investment is expected to generate host countries' development, and there are some restrictions on the capital flow out of the country. Such capital could be reinvested. It becomes a matter of concern for the host country as a sudden flight of capital might wreak havoc in the host country's economy. 3. Workers' rights. Poor working conditions and weak labor rights are sometimes reasons for multinational corporations to invest in developing countries in order to escape the stricter labor rights in their own country. These are issues of concern which needs to be addressed. Developing countries are faced with this challenge, but labor rights cannot be used to scuttle trade. A fine balance has to be struck. 4th, harm to the environment. The same issues which afflict labor also besieges the environment. Poor environmental standards coupled with governmental corruption can be a catastrophic combination for developing countries. As far as India is concerned, the Bhopal gas tragedy resulting in the death of hundreds of civilians and injuring hundreds of thousands apart from polluting the environment for a long time to come is a living example to learn from. Now we see how trade-related investment measures has started the trend for a global investment regime, though we haven't really reached that far. It had to be part of the Doha Development Round agenda, and it is always at the backdrop of WTO that a global investment regime had to be evolved, but something like that hasn't really happened. It would be good and beneficial both for the developed as well as the developing world if they can get together, engage, and come up with a multilateral investment regime for all the WTO member countries. And it is somewhere where both will have to understand each other's problems, adjust to each other's sensitivities, and move forward. Now, to conclude, trade related investment measures haven't really been able to capture the entire gamut of issues in investment. We see how throughout from late 1940s until today, we haven't really been able to have a multilateral agreement on investment. It is not, I am not talking in terms of MAI, which came out of the OECD. I am talking that any multilateral agreement, because after all, what we saw like from 1970s onwards, when there was new international economic order, and every year there used to be a General Assembly resolution on how there has to be absolute sovereignty over natural resources. There was a huge emotional value to it amongst developing countries, and every year they used to kind of reiterate the same thing. And then in the collective voice they used to reiterate complete sovereignty, but individually then all these countries had to agree to because they were all cash strapped, they needed cash for their development. So every time once the agreement was they used to enter into individual agreements with developed countries, and naturally so when you negotiate as a single individual country, your voice would be weaker as compared to a whole collective group, because across the developing, there are differences also, but across the developing and least developed world, there are certain issues which are of common interest. And not that there is no incentive for the developed world. For the developed world also there is immense scope, incentive, but there is also a sense, because they have the developed countries have been at an advantageous position for various reasons, including colonialism, that there is also greater responsibility in terms of ameliorating the vast masses of people across the globe. I mean, this would be the entire mass of people would forget whatever had happened during colonial times if they take up the responsibility, the challenge of today's world. This doesn't mean that companies invest not to make profit, but profit to what extent and how that profit is made becomes very, very crucial. That is where having a multilateral initiative, a multilateral agreement on investment becomes very, very crucial. Now, we will see that how we already saw how through the FIRA panel, from the back door, investment also became the national treatment, quantitative restrictions, they became applicable to investment issues, and the ambit has been widening ever since. But of late we see that the Doha development round did not take off, and so did the recent Hong Kong initiative also hasn't really taken off the way tempers were raised for it. Now this is where there is scope for all the countries to get their acts together, all the WTO member countries, and lead better future for all the citizens of this globe. Thank you.